The second case on this morning's docket. That is case number 114894, State of Kansas v. Jose Alberto Gonzalez Sandoval. Counsel, I'm going to give the audience a moment to leave the courtroom. Don't take it personally. I want to make sure that there's no disruption of the arguments.
One argument was all they could take. May it please the court, Chris Elslegger of the Attorney General's Office, appearing on behalf of the state. Mr. Chief Justice, I'd like to request 3 minutes of rebuttal time.
3 minutes is granted.
In this case, the Court of Appeals majority just lost sight of the purpose of Batson, which is to prevent racial discrimination in jury selection. It's not to test the accuracy of the prosecutor's information or the prosecutor's memory. Judge Malone, I think, got it right when he pointed out in dissent that the key issue is determining whether the prosecutor engaged in purposeful discrimination by removing a prospective juror based on race. But here, the Court of Appeals majority got hung up on whether the prosecutor's stated race-neutral reason was factually correct rather than whether it was race-neutral and honestly believed. And an honestly believed but factually incorrect race-neutral reason is still race-neutral. The only time a factually incorrect reason given would not be race neutral is if it was obviously a pretext for racial discrimination, and that's not what we have in this case. I've cited multiple cases from other jurisdictions, both federal and state, on this very issue. The Ninth Circuit says in Ailman v. Uribe, Batson prohibits purposeful discrimination, not honest, unintentional mistakes. And in U.S. v. Hendricks, Seventh Circuit said Batson and its progeny direct trial judges to assess the honesty, not the accuracy, of a proffered race-neutral explanation. And I think that's important here because after the prosecutors came back to Judge Wheeler and said, the reason we gave before, it was based on some false information. We didn't realize it at the time, but we still think that she didn't answer this question right. And ultimately, after the second or third iteration of that, Judge Wheeler said, well, look, I got it. You gave me mistaken information, but you honestly believed it at the time. So I still find it was a race-neutral reason. And that's critical because the standard of review, when you look at Batson violations, is abuse of discretion, and it really turns a lot on the judge's credibility determination.
But the judge also made a comment that, especially to defense counsel, after the prosecutor said, yeah, but we found all of these other things. And it seems like the judge turned to the defense counsel and said, well, you're still not going to make your objection, are you, in light of this new evidence? Which makes it seem like Judge Wheeler considered those new objections. So how do we separate that from his analysis? I agree he went on to say your original statement was, that I understand you honestly believed it at the point in time, but can we really separate what he shouldn't have considered from what he did consider or could have considered?
No, I think there's no separation there because quite honestly, when I reflect back on this too, it seemed like the attorneys and the district court and even the Court of Appeals to an extent conflated peremptory challenges with challenges for cause, because they not only did they went beyond just looking if it was race neutral. They started evaluating the prosecutor's stated reason, saying, well, is that good enough to remove somebody from a jury? And I think with the second person that was the defense attorney said, well, I think that's just too subjective to remove somebody from a jury. And actually, in that case, Judge Wheeler said, I'm going to deny the peremptory. And that loses sight of the whole fact of what a peremptory challenge is. It's not a challenge for cause. A peremptory challenge can be for any reason other than race.
I'm sorry. The judge also has to assess, doesn't he, if that reason is so superficial that it's really just a pretext for racial discrimination. And so how do we make that distinction?
Well, and in this case, I don't think you could say there's a pretext because it wasn't the prosecutors didn't bring new reasons in the face of being of challenges to those reasons, or to the judge saying, I don't believe that reason. The prosecutors brought it on their own after the judge had already decided that there's no Batson violation. Then they came back to the judge and said, hey, we want to be completely candid here. That information we received from our investigator was incorrect. We believed it at the time, but it's incorrect. But I don't think they actually needed to make another reason, because all that mattered is they honestly believed the reason they gave at the time. They weren't removing the person because of the person's race. They were removing it because of information that they had. Even though it was mistaken, it was honestly believed. Now, they gave additional information, but it wasn't pretextual, because it wasn't given in response to the judge saying, I don't think that you were, your first reason was race neutral. I mean, if the prosecutors wanted to be pretextual, they would have just kept their mouths shut after the first ruling. There was no reason for them to reopen it, other than
except for the discovery, perhaps later on, that counsel misinformed the court. That would have been perhaps even worse had defense discovered that.
That's fair.
Would you agree?
That's fair. Yeah.
Hopefully, you would come before the court because you want complete candor. You'd want to do that, but also there's a reason that, just in light of that, had defense brought that to the court's attention after voir dire had ceased and the jury was selected, would raise a different question, I think.
Well, yeah, that's fair. But I think that, again, that goes to the credibility determination that the trial judge made. I mean, these are attorneys that appear in front of him regularly. He knows them. He's going to assess their credibility and the defense counsel's credibility. Defense counsel said he didn't know anything about it. I think this is clearly a case where the prosecutors were just trying to be candid with the court and let the court know they made a mistake and they weren't trying to mislead the court. And I think when you look at Hernandez v. New York, the United States Supreme Court said that why you give deference to trial court findings in a Batson violation, because they largely turn on evaluation of credibility. There will seldom be much evidence bearing on the issue of whether it was a racial motive or not. So the trial judge is in the best state to evaluate that. They said it's with the state of mind of a juror. Evaluation of the prosecutor's state of mind based on demeanor and credibility lies particularly within the trial judge's province. And the trial judge made that determination here. He found that their reasons were credible. Again, I think
they were being honest. He said they were being honest. Yeah.
Yes.
Counsel, I want to go back. I think this kind of goes back to Justice Lukert's line of questioning. Can you just tell me exactly what happened in terms of what the judge was doing in response to this new information? Was he really returning to Batson to reevaluate? This goes to the issue of newness, because Judge Malone in his separate opinion says basically these weren't new reasons. It's just a correction of the record. Basically.
Yeah.
So, but what was Judge Wheeler doing in response? Was he reviewing Batson anew? Was he just acknowledging they were correcting a factual inaccuracy in the record? I mean, what was going on there? I think that, because I'm having a little trouble figuring out what the real pattern of our analysis on his decisions should be.
Well, if I recall correctly, I think when they brought the new information to him, he turned to Mr. Buck, the defense counsel, and said something, well, do you want to renew your objection? And I think Buck said, yes, I do. And then I believe that the judge...
But just allowing him to renew the objection, does that mean that he really went through the entire analysis? Because he doesn't flesh it out much.
To be honest with you, I thought everybody at the district court level got really sloppy with it. I mean, he didn't really do much analysis
on the
prima facie evidence of whether there was
wasn't articulated on the record.
Yeah, they didn't articulate all the steps, and I think that's actually pretty common, and I see that a lot in appellate cases where the judges, they kind of skip to the end.
It makes it hard for us to know exactly really what we're evaluating.
Sure, but I think certainly, I think the implication is that clearly he found there was no Batson violation. The reasons given were race neutral and were credible.
My question is along the same lines. To unwind this thing, what would have happened, or what should have happened if the district court, when the objection's renewed, if the district court grants the objection? I mean, I don't understand what would practically have happened. I mean, how do you rewind everything that happened back to when, I think it's TR was removed from the pool and put TR back in the pool? Like, you already have a jury
Yeah.
impaneled? What happens?
I struggled with that myself in analyzing the case, and I think that while voir dire was going on, I think it was still going on the first time when the second prosecutor came up and said, "Hey, look, there was a mistake." I think at that point the judge could have said, "Okay, we're going to start over." I don't think he would have brought TR back. I think she'd already been removed, so I mean that was gone. But I think they could have reset the process.
Mistry? Or
Well, I suppose. I mean, I
The
think
Court of Appeals opinion recites the timeline as follows: that there was the mistaken reason proffered, which was accepted as race neutral. TR was discharged from the pool. Then, I'm just looking at the Court of Appeals opinion, the 12-person jury was selected. The court held a recess for lunch, and it was after the lunch recess that the prosecutor came back and said, "We made a mistake."
Okay.
Is that right?
that was the first
That-
time, I think.
Yeah.
if that's what I've got no reason to argue with that.
I'm just trying to get in my mind the universe of options that would be available when you've got this scenario that occurs and the jury's already been selected.
I think then the only option, and I'm shooting from the hip, but I think would have been a mistrial at that point in the new jury selection. If the judge said, "Hey, I don't buy your explanation. It was
Right.
it was race."
Or maybe it's not that I don't buy it, it's that because this information was not known by the defendant did not have a fair opportunity to argue pretext.
But again, I think that conflates the peremptory challenge with the.
Well, you would agree that in the Batson procedure, the last step is to ping pong back to the defense and give the defense an opportunity. It may avail them little, but an opportunity at least to try to establish pretext. And if the defense is deprived of a key fact, that might weigh on the pretext question.
Possibly,
Weren't they
but
deprived of that opportunity?
That's going to be the case in every. I mean,
Every
generally-
time the prosecutor gets the facts wrong, that's going to be the case.
Well, but courts have, as I cited, legions of case decisions that said, look, a mistake of fact, even if mistake, even if it's wrong, it's still race neutral.
I get that. At least if it's honestly held. But,
Yeah, and
but
it's hard.
that cuts off the analysis, and it doesn't. I'm not suggesting that the defense would have prevailed on that. I'm just saying, doesn't it limit their ability to avail themselves of at least the opportunity to try to demonstrate pretext?
No, I mean, they still have the same opportunities as say, in Miller L. I think demonstrating the pretext is very difficult, but I mean, you could show side-by-side comparisons. They could, challenge
saying they could have said, if they had known the facts, this is obviously pretext because it's not even true.
Or they didn't investigate anybody else.
Yeah, but the thing is then you, and that kind of gets into the second issue that the Court of Appeals raised. That would essentially establish a discovery process for peremptory.
I don't want to do that yet. I'm just trying to get to the heart of his question. What should happen? So,
I'm not sure I'm following the question. What should happen? I mean, the defense has their opportunity. Their opportunity, as the Supreme Court has identified, is always going to be limited.
Yeah, your position is just we made an honest mistake,
Yeah.
and the defense is out of luck.
And your position is and I guess the case law holds it, that it's okay if it's an honest mistake of fact.
As long as it's not
And
racial.
I just don't understand, why does that still, the race neutral reason given was not valid? And so don't we go back to what other reasons were given? And there really wasn't much else other than this mistaken but honest belief.
Well, you have to go back to the whole purpose of Batson. Batson is to prevent racial discrimination in jury selection.
And so how can that happen in this instance when the race neutral reason was wrong?
Because it goes to the motivation of the prosecutor. Even though it was wrong, the prosecutor believed it. So the prosecutor's motivation was not racially based. And a peremptory challenge can be for anything. It can be, I
appreciate the wide latitude we've given here in the Batson, but when it's a wrong, I don't know if you've ever gotten to when it's wrong.
Well, and
We've given great latitude about what suffices for race-neutral reasons. You would agree with that, I think.
yeah, I mean, so is the United States Supreme
But a
Court.
wrong mistake.
Again, it goes to the motivation, because even though the information the prosecutor had, it was wrong. She didn't know it was wrong, but she believed it, and that's why she didn't want the person on the jury. The reason she didn't want the person on the jury had nothing to do with the race.
I understand
And
that. Yeah.
That's all Batson's for.
And to follow up on that, I'm looking at the second step in Batson. And it says the reason offered will be deemed race neutral unless a discriminatory intent is inherent in the explanation. Is that what you're basing your argument on, and what these other courts are basing their positions on?
I believe so. You know, and you have to look to like the Miller L case to find a real discriminatory intent, where there was a pattern of discrimination, where you looked at the statistics, how many minorities were in the jury pool, how many were removed, how the fact that particular office would shuffle the minority jurors to the back so they wouldn't even get questioned. There was a policy in that office. There's lots of reasons in the Miller L case where they showed discriminatory intent. In a case like this, you know, it is hard, and I think it was intended to be difficult, because the point of Batson was not to dig into the weeds of peremptory challenges and turn peremptory challenges into challenges for cause. The only reason for Batson was to prevent attorneys from throwing minorities off the jury just because they're minorities. But any other reason is good; it will suffice, and that's the purpose of Batson. And I think Batson has largely achieved that purpose. So the reason just has to be racially neutral, and this court and the United States Supreme Court have said over and over again, the reason does not demand that second step does not demand a prosecutor's explanation that is persuasive or even plausible. It just has to be race neutral, and so that's why a mistake, an honestly believed mistake of fact, is still race neutral. It's not tied to race, and that's all that Batson is for. It's not to further delve into the peremptory challenges. That's what challenges for cause are about. And I see that I'm out of time. If there are no more questions, I'd like to reserve the rest of my time for rebuttal.
Any more questions? All right, thank you, counsel.
May it please the court, Chris O'Hara again appearing on behalf of Jose Alberto Gonzalez Sandoval. It's been mentioned by counsel that and argued with this case that this was just an honest mistake, or was just a mistake by the state in the reasons that they gave initially for striking the juror TR. And I would argue that I don't know that that's necessarily accurate given the circumstances and facts of how this actually happened. In this case, the voir dire was going on, and even if you accept the arguments made by counsel and also the arguments made by counsel at the trial court level that they had this information, they elected during voir dire not to question TR about the information that they had. Had they simply done that at the time, then they would have resolved a lot of the issues, and the issues that they had with the information. They would have known right away that it wasn't accurate. And I think when they
here's my
don't,
problem with where that, I think that argument ends up in a place that nobody would want to go. I mean, as your opposing counsel said, made the point several times, peremptories can be for any reason. I mean, they can be, you think somebody with that employment is going to be inclined to rule against you or to find against you. I mean, they can be for anything. But where would the rule that you'd like to have stop?
well, I mean, I think that we have it. We have the Batson test. And I think initially...
I thought you were getting ready to tell us that there had to be some sort of disclosure to the defense of everything the state might question about every member of the panel, and that you would never finish voir dire. It would just go on forever.
Well, and I think what they did in this is somewhat of a unique situation because they had their own investigation of the jurors, and they conducted their own investigation. The state did. They had an investigator who looked in. We don't know which jurors they looked at, and when they don't question the potential juror of the information they think could potentially disqualify them, or potentially the reason why they would want to strike them, then this is the scenario that you get.
Then aren't you,
I guess I wanted you to complete the sentence before you started telling me that they had this information in advance and could have done something else. Are you trying to say that the circumstances of this case point to pretext?
Well, I don't think we know necessarily what it is. And I would suggest, I think that what we do know from what happened at the trial court level is that the two reasons that they gave three reasons. One was eye contact, and they gave the additional two reasons initially when Mr. Buck made the Batson challenge. What we do know is that the other two reasons that they gave that the court was looking at were incorrect. And in our opinion, at that point, the Batson analysis and the Batson hearing ends. And then they select a jury, and then it's not until later on that they come in and say that these two other reasons are inaccurate.
So is the issue, from your perspective, that the district court did not do an adequate inquiry into whether this was pretext?
Well, I think that I would suggest that you would like to have a more thorough record, obviously, of what the reasoning, what their analysis was at the time. But I don't think you can tell from the record itself that they initially ruled on the second reasons that they gave and said that they were okay at the time, believing them to be accurate, believing the representation to be accurate.
I guess the issue I'm getting at is it seems to me these lawyers are coming in, the state, and they're saying, ooh, we made a mistake. We want you to know that we made a mistake for the record. And doesn't that mean that the issue in front of the district court is whether these guys are really trying to racially discriminate and hiding and now trying to just cover their tracks, so that the issue is pretext?
Well, I think that could have been an issue, obviously, at the time that you would have liked to see the district court or trial court address. But the way this actually occurred at the trial court level, that hearing was done. The hearing was done at the time because they had given a representation as to why they said that there are two reasons as to the 1, 2, and 3 reasons as to why they said that they were going to strike TR and peremptory strike TR. And after that, then the jury was ultimately selected, and they didn't disclose that the second 2 reasons were incorrect until after that had happened.
What should have happened at that point?
Yeah, that's what we're getting. We know the facts.
Okay.
Just what was supposed to happen here.
Are you asking what's supposed to happen then once they make that?
Once they disclose that they were wrong and the reasons they gave the court.
A mistrial. It should have been a mistrial at that point.
Why?
Why?
What is the underlying reason that would justify the mistrial?
The underlying reason is because the reason that they gave was facially invalid.
An innocent. So you are saying that that a mistrial is justified even when everyone agrees there was no discrimination in the exercise of the preemptory challenges. I mean, that's the problem I'm running into, at least, is you're saying we should have had a mistrial even though the facts demonstrate that there was no racial bias exhibited by the state.
But I don't know that the analysis at the time and the facts, then I understand what the court said later on after the 4th reason was given, which was different than the other 2, that they believed that it to be an honest mistake, or that they were candid with the court and they believed them to be honest. But when you look at the circumstances of what happened with this, I don't know how you could say, or the trial court could say at that time, that it was not pretextual.
But at that stage, doesn't the defense have the burden to show the pretextual nature? And what efforts did the defense make to show that, to push that point?
Well, he continued with the objection. He never let up off the objection.
Just
Is
objecting,
that enough to
enough?
carry a burden?
Yeah.
I would argue with the situation that they had at the trial court level, yes, that it is.
You're just saying inaccuracy equals pretext, end of story.
Well,
As soon as inaccuracy is detected, no matter how honestly believed the inaccurate statement was, the defendant has met his or her burden of showing pretext on the third step of Batson. I mean, I think that's what your rule is.
no, I don't think that. I think there are certain situations, even with some of the situations cited by counsel, that are different than what we have here. What we have here is a situation where they said they had this information. There was no diligence that appeared to be exercised, and they were very careless with this information that they claimed they had, and it ultimately turned out to be inaccurate.
Can I clarify something here? One of the reasons was that TR was untruthful, and that was because they asked a question of the entire panel, and she didn't offer up the information. Is that accurate as to what happened?
That yes.
And so when the peremptories were made, the veneer persons are still there. Would the defense have the opportunity to say, I want to individually reopen voir dire with respect to this woman and see if she was untruthful? Because it was lying by silence, because they believed she didn't offer up. No one asked her directly the questions, and that's part of what you're saying is that if the state's going to rely on silence, then they should at least have to individually voir dire this individual. I think that's what you're trying to get at. But what my question is, when they do the peremptories, procedurally, can the defense reopen questioning and see if the state's being accurate?
Well, I would say at that stage, I think they probably could. I mean, as long as the voir dire is still pending, I think they could continue to ask questions of the veneer person. And again, it's a situation where they had this. I think if you look, I mean, when you look at this, we're taught as attorneys and lawyers that, and especially with criminal, that you look at you have no way of actually getting inside somebody's mind to determine the intent. Obviously, each person's different. We can't get in their mind to determine how they do things or why they do things. But we're taught that you look at the facts and you look at the circumstances around a situation, and that helps you determine what intent is. And that is true of jury trials and a lot of situations involving the law when you give instructions to a jury. If you look at the situation that we have here and the facts surrounding this, I mean, it's not right.
Let me interrupt and point you to the Batson procedures. Basically, it's as defense counsel or the person who is opposing the strike by the state, to carry the burden of proving purposeful discrimination. So just to put your analysis in terms of that test, and the court goes on to say the step hinges on credibility determinations. The best evidence is often the demeanor of the party exercising the challenge. To help me understand your position, can you tell me what proof of purposeful discrimination was shown here?
Well, if you go back to, I guess, in the second prong of Batson also, in the middle of that, it says the reason must be facially valid. In this situation, the reason was not facially valid. The second two reasons given were not facially valid reasons.
Because they were not accurate. So do you have any authority that counters the state's long line of cases that say that inaccurate information is necessarily dishonest?
Well, I don't.
Or facially invalid, is facially invalid?
Well, I think that even the opinions, specifically the Miller L. opinion and the other opinions cited within the Court of Appeals, address those issues. And I don't think factually that's the situation that was just here. This is information that they had that was wrong. It's not just that it was inaccurate, it was completely wrong.
Okay, so just to pin down so I'm sure I understand what your argument is. Are you disputing or asking us to revisit the judge's finding that the prosecutors made an honest mistake?
Well, I think that what the Court of Appeals opinion said was that once the voir dire, after the jury was selected, the Batson hearing was over. The Batson hearing with regarding that was over with, and they gave their reasons why. That they thought that the jury, they gave their reasons at the time, which were 3, as to why they struck TR. And the Batson hearing at that time was over. It's not until after they select the jury that the state comes in and says then that reason number 2 is inaccurate. And then it's not until the trial started that they come in and say reason number 3 is inaccurate, and then they give a completely different reason.
If it was
But
over, why did the judge ask if the defense still wanted to object?
Well, I don't know, and I would assume it's because it was brought to the attention of the court, but I don't know, how could you have a Batson hearing once
Mid-trial, yeah.
once the trial's going on?
Jury selection's obviously over. I'm sorry, did I interrupt you, Justice Luker?
Well, you don't feel like you had any obligation, the defense had any obligation at that point to go forward with showing pretext?
Well, I think
Either-
I think at the time he made the argument, I think obviously you would like to have more detail with something, but I think that he properly reserved the issue.
But let me circle back to my question because I'm not sure I heard the answer. Are you asking us to, for example, apply a substantial competent evidence standard or do some other, what appellate standard are we applying to the argument? And is your argument that we need to revisit the judge's ruling that the prosecutors made an honest mistake?
No, we're asking that you follow the decision or affirm the decision made by the Court of Appeals. And I think that it
understand
cites
that,
the
but does
Miller
that
L.
include a revisiting of the credibility finding of the judge,
Well,
in your view?
Well, I would agree with the Court of Appeals decision in saying that finding is irrelevant, because what it said is that hearing was over, that the Batson hearing was over by the time once they had made the argument initially.
You're back to a factual error makes it facially invalid. Ipso facto, that's the end of the Batson challenge, and the defense should win. I mean, Justice Breyer asked that, I think, a few minutes ago, but that really is, it seems to me, the position you're taking, right?
Well, yeah.
If the honesty of the prosecutor is irrelevant.
Well, I'm not suggesting that it's irrelevant in every situation, but in the situation that we have here, I don't know that the court's ruling that it was an honest mistake was made when the 4th reason was given. That's when they said that. It was not at the time of the Batson hearing. And I think when you look at the overall circumstances of this case, I don't think you can necessarily say this is just an honest mistake. That there should be some element or requirement of due diligence. And I mean, this guy it's an off-grid felony.
Well, Counselor, the question that the Court of Appeals posed was, can the state provide substitute race-neutral reasons for striking a minority veneer member once the original reason failed because the reason was either facially invalid or deemed pretextual? That was the question they posed. And if we agree with the state that factually inaccurate does not equate to facially invalid, and we don't have any ruling from the district court deeming it pretextual, then why wouldn't we say the Court of Appeals is wrong? If they answered that question, no, you can't have substitute reasons for facially invalid or deemed pretextual, but that wasn't the case in this here. You understand what I'm saying?
Well, I guess not exactly, no.
Well, you want us to follow the Court of Appeals, but if we find the Court of Appeals, the premise of the question they answered is incorrect, that here we don't have a facial invalidity, then how can we how can we affirm?
Well, I do think here we have facial invalidity. I think it is. I think it's completely because the put facially invalid because the two reasons that they gave.
And that's your argument. But my question was, if we follow the cases that say factual inaccuracy does not equal facial invalidity, then how is the Court of Appeals correct?
Well, I think it's again when you look at the overall circumstances of this case, I think the factually when you look at what happened here, it's distinguished from the cases cited by counsel, and I think it supports the decision made by the Court of Appeals, which that the reasons that they initially gave were wrong. And
We've got that. I know everybody admits that they were wrong. I don't get the difference between factually inaccurate and wrong. You made that a couple minutes ago, and I don't understand it, but it doesn't really matter for our purposes. Let's just accept, for purposes of argument, that they're wrong. What my colleague is trying to get you to address is if we don't buy the premise that factual inaccuracy equals facial invalidity, if we don't buy that, if we just don't accept that part of your argument, then we have to go to whether there was pretext shown, and that was your burden, right?
well, then if you don't accept that premise, then I would say at that point then that the
Can you win? That's the question. Can you win? Can you prevail here if we don't accept that premise? Is there any way you prevail? That's his question, I think, isn't it?
Thank you.
Well, I mean, I think that yes, I think we would win. I think we can.
And we just want to know how you do. That's all we're asking.
I don't think there was an analysis at the trial court level regarding the pretext.
Okay.
I would agree that it was not a thorough analysis with the Batson challenge.
So the fact that it was sufficiently, that it was not thorough or it was insufficient is how you win.
Well, and I think that Mr. Buck at the time when he made the objection, he addressed what the issues were. He again did not have the information that the state had. So he couldn't get into the details. I mean, this is again the problem you run into when this isn't addressed in voir dire. But he couldn't get into the details about what their reasoning was. And so I think his objection at the time and his argument at the time would preserve that issue, and we would be allowed to win on the fact that it would have been pretextual, given the hypothetical.
Thank you.
Counsel, you're out of time. We've taken up a lot of your time with questions. Would you like 30 seconds to wrap up, or do you think you've made your points?
I think I made my points. We would just ask, I think if you look, I mean, at the situation as a whole, and you look at what happened here, I understand that, prosecutors can, in certain situations, make mistakes, but this was a situation where a guy is it's an off-grid felony, and it's a very serious matter. And I think that a certain amount of due diligence and regard for what was going on should have occurred, and they certainly had an opportunity to address these matters during voir dire, and I think that would have solved a lot of the issues. And we would ask that you affirm the Court of Appeals opinion.
Thank you, counsel. Counsel, before you do sit down, can you tell us what your best case is that's closest to the facts we have in this case? Because I understood opposing counsel to say that they were not analogous. Can you direct us to a particular case or two that you think cement your position?
Well, the closest Kansas case, I think, is Trotter. It's not directly on point, but basically in Trotter, the court, the prosecutor made errors in his stated reason, and the court said that the defendant or the trial court do not correct errors in the prosecutor's statement of facts supporting his or her reasons for exercising peremptory challenges. These facts are considered to be true for purposes of determining whether the prosecutor set forth a race-neutral reason for the strike. It's not exactly on point here because I don't think that the trial court or the defense could have corrected the errors as they could have in Trotter. I think in Trotter it involved a misstatement of an answer to a voir dire question that everybody would have known. Although, as Justice Johnson pointed out, had defense counsel had a problem with the reason given in this case, they could have probably requested individual voir dire to explore with that particular juror. But I think really what Trotter stands for, though, what I want to pull out of it is that the mistake is, in Trotter, there was a mistake, a fact given as a reason for a peremptory challenge, but the court said it's considered to be true for determining whether the prosecutor set forth a race-neutral strike, which I think leads into what I wanted to say when I first got up here, that when we're looking at whether a reason is facially valid, in the context of Batson, a reason is facially valid if it's race-neutral, if it's not race-based. And here, in the context of Batson, the reasons that were given by the prosecutors were facially valid. On their face, they were facially valid. They were race-neutral.
Counsel, I understand your argument that there was no racial discrimination exhibited or proved up here. I guess one place I'm hung up at is, had the state not made the error, TR would have been on the jury, or at least would not have been struck. And I understand there's the later reasons given and so on, but just accept for the purpose of my question that premise, that had the state not made this mistake, TR would have been on the jury. Should we care? I mean, should that factor into our decision? And if not, why not?
Well, I guess I don't want to follow your hypothetical all the way because I don't know that it's certain that she would have been on the jury. The other, I mean, they had other reasons. The first reason they
yes,
gave,
I understand there were subsequent substitute reasons given.
but even before that, the not making eye contact,
well,
I think
the judge found that was not an acceptable reason.
Okay.
But just, again, except for the purposes of my question, the premise that had this, because certainly you could imagine a scenario where the state makes a mistake, and even the state maybe in admitting the mistake might even go so far as to say, we don't have any substitute reason. Like had I not made the mistake, I wouldn't have even exercised the preemptory.
Okay.
In fact, that would be a better defense to say this was not racially motivated. Okay. And I just think what I'm confronting is that upon review, and even in this situation, after the jury's impaneled, everybody just may be stuck with that mistake. And I'm just wondering, I mean, is that right, that we just say we're stuck with the mistake? Because that's how I understand your argument.
Well, I would say that no trial is perfect. Mistakes are made in every trial, and we're often stuck with mistakes.
There's no way to evaluate prejudice, though, is there?
Well, I don't know that. I want to circle back around to the other aspect of this, which you've asked about, is whether they, the third step of Batson, whether the defense carried their burden of proving racial discrimination, because that's ultimately where we're at, what we're getting to, not whether there's a mistake in the reason for the peremptory, which again I'd reiterate would be for any reason other than race. But when I went back while I was sitting down and reread the portions of the transcript there, and I would say that once the prosecutors gave their race neutral reason in every case, the defense counsel didn't really push or make an argument for racial discrimination. He didn't make that third Batson argument. Instead, he kind of argued, well, that's not a good enough reason to throw somebody off the jury, as if we were arguing about peremptory challenges. So he never really did.
Your point.
Yeah.
Well, let me summarize and ask you if this is your point. It sounds like you're saying, look, the reason it's okay to accept this mistake is because the defendant doesn't have a right to have any particular person serve on the jury. All they have a right to is to have a jury that's not polluted with discrimination. And they got that. So whether TR serves or not is really irrelevant. Doesn't matter.
That is absolutely correct, Your Honor. And if there are no further questions, then I would simply I would conclude my argument and ask that you reverse the Court of Appeals and rather agree with dissenting Judge Malone and affirm the district court findings.
Before you sit down, counsel, I think it was Batson or maybe another U.S. Supreme Court decision in talking about this general subject said, part of the rationale here is the right of the juror to be seated unless kicked off for a cause or valid peremptory challenges. So I'm just kind of curious, what do we tell this person here that she was incorrectly kept off the jury.
Yeah, I've read that in some cases too. That there's also, it also protects the right of minorities to be on juries. I would say I think Batson is more writ large, and it has achieved its goal of stopping what I assume prior to Batson was probably rampant racial discrimination in some parts of this country. I don't know that it. My take on that is that's more of a writ large right for society and for racial minorities in society, not an individual right. I don't think that anybody could have a cause of action to say I was thrown off of a jury invalidly. I don't think that's an individual right. I think that dicta in those cases is speaking more to the broader societal right of protecting minorities and their opportunities to participate in the process.
Very good. Do we have any further questions? Thank you, counsel. Thank you both for your arguments this morning. The court will take this matter under advisement.